Florida Governor Ron DeSantis goes after big banks for dropping gun companies. Plus, Four Boxes Diner host Mark Smith gives us an overview of the legal landscape post-Bruen. That and more on this episode of the Weekly Reload podcast.
Oh, the devil's got no hold on me.
All right, welcome, ladies and gentlemen, to another episode of the Weekly Reload podcast. I'm your host, Stephen Gutowski. I'm also the founder of thereload.com, where you can head over and sign up for our free newsletter if you want to keep up to date with what's going on with guns in America. I'm also a CNN contributor. I mentioned that because for those watching on YouTube, today I'm wearing a suit. I just got back from an interview I did with Jake Tapper, and I didn't have time to change into my normal casual outfit for this show, but hopefully you can bear with me here. We have someone worth dressing up for on the show today, actually. Mark Smith with us to talk about what's going on in the legal side of things since Bruen. You know, we've talked a lot about specific cases and stories here, but I think this week it'll be good to do a general overview. So, Mark, welcome to the show. You tell people just a little bit more about yourself.
Come on, Steve. First of all, we know you dress like that in the range. I've seen the photograph. So who are you kidding talking about being on CNN? That's how you shoot. When you shoot your AR, you dress exactly like that.
Sometimes.
Well, I think, obviously I run the Four Boxes Diner Second Amendment channel on YouTube and talk a lot about, like I say, the geeky inside baseball of the Second Amendment litigation and legal world, and try to really drill down into what's going on in the courts. And I try to also explain, what's happening, how to look down the chessboard, how are people trying to maneuver both the pro-gun side and the anti-gun side, what's the strategy, and how to think about some of these. Because sometimes you see something that appears to be a win, but it's really a loss, and sometimes you see something that appears to be a loss and it's really a win. So I try to break it down, and I try to look down the chessboard. For example, before Nyserpa versus Bruen came out, Steve, I was talking about the dangers of the notion of sensitive places, that as soon as the gun control movement was going to lose Bruen, which I anticipated, they were going to try to declare everything a sensitive place, which is a government mandated gun-free zone, which is where they've gone, not so successfully. I think that's not going to work for them, but that's exactly where I anticipated they were going to go, and that's where they went. So I try to, again, predict a little bit and tell people where I think things are going to be going, the good, the bad, and the ugly.
Yeah, and you're an author and a lawyer as well, so you know quite a lot about this topic, and I've always trusted your analysis. Whenever you put out a video, I try to watch it and get a good feeling for where things are at. I think you're very reliable in that regard. You don't put forward a lot of clickbait or sensational stuff. I think your content is very solid, and that's why I wanted to have you on my show. I was on your show once before, and so I figured it was time to do a crossover.
Great.
And have you on here. But because that is one of the things I really enjoy about your content and your writing, and I've seen you speak as well, is that you focus on the strategic, big picture stuff. It's not just here's what happened in this case, as important as that is, and you obviously do analyze individual cases and their outcomes too. You have a knack for seeing the long term and how things are going to move down the road. So let's get into that part of the discussion here. Bruen's happened last June. It's not that long ago, right? Especially in constitutional law terms, right? But there's been quite a lot of development to this point. Where do you see things as of today in terms of how federal law has changed as a result of Bruen?
Well, I think the Second Amendment movement is doing extraordinarily well in the courts. You have to keep in mind, Steve, that Heller versus the District of Columbia was decided in 2008. From 2008 to 2022, you had really a rebellion among federal judges in many parts of the country to try to ignore and pretend that Heller didn't exist and try to find excuses to ignore our fundamental right to keep and bear arms. But since Bruen, we have literally won more Second Amendment cases by orders of magnitude in the last 7 or 8 months since June of 2022 than we had done so in the prior 10 plus years. And I think that alone tells you a couple of different things. First of all, it tells you just how powerful the sort of analytic methodology of NYSERPA versus Bruen was. Because when you do high-end constitutional litigation, Steve, it's not just who wins the case. Of course, who wins the case is very important. But equally important is how they win the case, the methodology that gets applied, because the Supreme Court only takes about 80 cases a year. So when they decide a case, it's not just about who's the winner, who's the loser. It's also about what is the teaching tool, the methodology, the legal approach that they're trying to teach the lower courts what they should be doing going forward in similar cases. And with NYSERPA versus Bruen, by saying to the lower courts, look, the founding fathers told us that the balancing of interest between the good of guns and the bad of guns to the extent that exists has already been done for Americans in the form of the Second Amendment. That was the outcome of a balancing set of interests by our founding fathers, balancing, the government authority and power on the one hand against individual freedom on the other hand. And that gave rise to the text of the Second Amendment. And now the Supreme Court says going forward, we want text and history and not balancing tests going forward. And that's made a big difference, Steve.
Yeah, I think that's a really important point about Bruen itself that gets overlooked a lot. Thomas talks exactly about this, about how the Second Amendment itself is the result of a balancing test. And so taking that and then applying a balancing test on top of it doesn't make any sense from his point of view, right? And it's something I think gets lost a lot in discussion of Bruen, right? You focus on the text and tradition aspect of it, because that's how you practically go about making a decision under the standard. But why they went with that often gets ignored when people talk about Bruen. And I think that's a really key point here. The balancing test. Americans have, through having a Second Amendment in the first place, has already determined that gun ownership in society is valuable and outweighs the negatives that come along with it, right, as on a whole.
Absolutely. In fact, Justice Scalia said this exact same thing in Heller. He specifically said at the end, as you know, Stephen, he said, look, the founding fathers did this. So, coming to court to talk to judges about the application of the rule of law to a particular case should not involve balancing of interest as a matter of public policy. Public policy decisions are made at the constitutional level by guess whom? We, the people. The American people enacted the United States Constitution. It's been amended, by the way, 26 times. So it's not like you can't change it if you want to. But of course, the left wing in America, Steve, wants to change the Constitution the way they want it to go through using unelected judges. That's been their modus operandi from the beginning. They don't like to go through the constitutional amendment process to speak to we the people. They would rather have unelected bureaucrats, unelected judges make those modifications to the Constitution, because frankly, it's a lot easier to do so, but that's not how our system is supposed to work.
Right. And so you mentioned here that there have been a lot of rulings post-Bruen, a lot, and especially compared to that period between Heller and Bruen. What are some of the biggest rulings in your mind? What are some of the biggest cases that have come down thus far?
Well, I think there's a whole host of them, and they come all over the country. A lot of these occur even in the so-called blue states. And I just want to say, before I drill down into what I consider the big ones, judges in the American system, or the English system, which is known as the common law system, which means that case law builds upon case law, builds upon case law, which means Judge Gutowski makes a decision. Judge Smith looks at your decision and bases his decision on that. Then Judge Sotomayor bases a decision on that. And then Judge Barrett makes a decision based on that. So there's a building block process where every case decision becomes a precedent, which is analogous to like a brick. And every legal case in favor of the Second Amendment is another brick building up support and protection of our right to keep and bear arms. So with that in mind, what happens is, because we've had so many judges have stepped up and applied NYSERPA Bruen versus Bruen correctly in support of the right to keep and bear arms, I think what you're seeing is other judges are seeing the prior judges ruling in favor of our rights, and they feel more emboldened, like, hey, I'm on the right path here. I'm not an outlier. And what we're seeing all across America is judges relying upon other judges to advance the right to keep and bear arms in a way that we hadn't seen in the decade before NYSERDA versus Bruen. And that is making a big decision. And I like to talk about this on my channel, The Four Boxes Diner, that every one of these victories for the Second Amendment emboldens and encourages and reminds other judges that this is how you do it. You're not out there by yourself, being some, crazy person, outlier judge. You're doing what everyone is doing because it's the way it's supposed to be done. But as to the major decisions, I think there's a ton of them, depending on how you want to look. But I mean, just look, let's just take a look, for example, in Oregon. Even though you had a federal judge that on TRO did not get it right when it comes to so-called large capacity magazines, which is, are standard capacity magazines. If you look at the state court judge in Oregon, he felt comfortable enough under the Second Amendment through the sort of the states. He used the states' constitutional rights there, but basically a lot of his analysis seemed and had a feeling of NYSERDA versus Bruen. He enjoins this entire referendum that was enacted in November by the people of Oregon, so to speak, to violate constitutional rights. And you had a judge that felt comfortable saying, no, this is not right. This is not constitutional under the Oregon Constitution. And he enjoined the entire law. And then the Oregon Supreme Court says, yeah, we're going to let this go forward. We're not going to intervene if this lower court judge thinks there's a problem under the Constitution of Oregon. We're going to let that lower court stand in favor of gun rights and gun owners. And I think that's kind of an illustration of how judges that recognize the importance of the right to keep and bear arms and the fact that it is a constitutional right, a fundamental constitutional right on par with the right to free speech, the right to a free press, the right to religion at the church or the mosque or the synagogue of your choice. I think we're starting to see the implications of the Supreme Court really putting their foot down in June of 2022 in Bruen and saying, enough is enough. You respect this right like the rest in the text of the Constitution.
Yeah, you've seen that sort of logic play out in a number of cases, right? The Fifth Circuit case on domestic violence restraining orders and the gun ban associated with that. There was also there was a case out of Texas, a federal case that dealt with the prohibition on obtaining firearms if you're under felony indictment but haven't actually been convicted of anything yet. And both of those cases, I think they really get at this idea of these rights are, the Second Amendment rights are on the same level as First Amendment rights or any other rights contained within the Bill of Rights. And you need a higher level of evidence and scrutiny in order to take those rights away. This sort of seems to be a common theme in a number of these rulings so far. I mean, is that
Absolutely.
Do you see it that way as well?
Stephen, just going across the country, we have, obviously certain aspects of California's crazy gun control law remains, enjoined by Judge Benitez out there in district court in California. We just talked about the Oregon temporary victory where, the Oregon referendum in terms of gun control was enjoined. We see in Illinois where, Governor Pritzker helped pass a so-called assault weapon ban. That has been enjoined on the grounds that is unconstitutional. Then we see places like Colorado, where you had actually two Democratic appointees to the federal bench. I think one was an Obama judge. I think one was a Biden judge, and they both enjoined so-called local assault weapon bans in the state of Colorado. In New York, we know what's up in the Second Circuit getting argued on March 20th, but in New York, you had multiple decisions, both by Judge Sinatra in federal court in Buffalo, but also Judge Sotheby in the Northern District of New York, which I think he was in the courthouse in Syracuse, enjoining the so-called sensitive places rules about where people with concealed carry permits are allowed to carry a gun, where they're not allowed to carry a gun in places like Times Square, and so on and so on. We also have seen victories, against the ATF, for example, Cargill versus Garland, although that's technically a regulatory decision applying like the Chevron doctrine and questions about the rule of lenity and what authority the ATF has. But that was a terrible blow go from the point of view of the ATF in favor of gun rights in that case of Cargill versus Garland. And that involved, of course, the bump stock ban, which was, to me, unconstitutional and illegal for a whole host of reasons. But again, we saw a major victory down there. And last but not least, in Joe Biden's home state, Stephen, right, we have a case called Rigby versus Jennings, where a federal district court judge in Wilmington, Delaware, the land of Joe Biden, came out and says, you have a Second Amendment right to make your own gun, and the state's ghost gun law, which is a euphemism for just a gun that you make, that was unconstitutional under the Second Amendment. So this is just a handful of major victories that we've seen here in the United States in the last 8 months or so. And I think there's a lot more coming, because we just had a major argument this week in the Third Circuit Court of Appeals, which is the question of whether or not, in that case, it was a guy who had been convicted almost 20 years ago of a $2,000 misdemeanor welfare fraud. I think he and his wife had somehow filled out the wrong paperwork or improperly filled out the paperwork, and they got like $2,000 in public benefits they weren't entitled to, and they pled guilty to a misdemeanor. And this guy, under federal law, because he potentially could have gone to jail for more than 2 years under federal law, he lost his right to keep and bear arms for life. And the Third Circuit Court of Appeals, based in Philadelphia, heard argument this week, and it seems to me, by every indication, they're not sympathetic to the government's position that says if you commit a $2,000 misdemeanor, so-called congressionally defined felony 20 years ago, you lose your gun rights forever. It did not seem like the court was sympathetic to that governmental viewpoint. And it looks like we may be on the road to a major victory in the Court of Appeals for the Third Circuit coming up in a few months.
Wow. Yeah, that's fascinating. I mean, I want to get into sort of the broader legal arguments that are out there. But first, let's talk about some of these specific issues that you've mentioned here. Assault weapons bans. Do you see any of them surviving post-Bruen scrutiny?
No. Now, this is very important for people to understand about any kind of arms possession ban. When you're dealing with a ban on an arms, now that could be a law that bans the possession of AR-15s, which, as you know, are nothing other than semi-automatic firearms. If you're dealing with a ban on so-called large capacity magazines or a ban on ammunition, these are forms of arms under the right of the people to keep and bear arms shall not be infringed. The reason why this is important is because the United States Supreme Court, in the Heller decision in 2008, already did the analysis of looking at the text of the Second Amendment and then looking for historical analogs of any longstanding traditions of restricting or banning firearms of any sort, and concluded that if an arm in modern day America is in common use, it cannot be banned, it cannot be thwarted, it cannot be banned. Period, full stop. Now, all of these so-called assault weapon bans deal with semi-automatic rifles and magazines that hold more than 10 rounds. These are clearly arms, and they cannot be banned because it's understood by the world that these are in common use for lawful purposes. Now, the anti-gunners are trying to redefine that standard to say the legal standard is not that an arm has to be in common use for lawful purposes. They're trying to redefine and say, no, that the pro-Second Amendment people have to show that these arms are in common use for purposes of self-defense. But that is absolutely 100% not true, because if you just look at the dissent of Justice Stevens in the Heller case, he and his fellow dissenters, including Ruth Bader Ginsburg, talk about how now they disagreed with this test, but they pointed out that the in common use test by the Supreme Court was discussing in common use for all lawful purposes, including hunting, self-defense, recreational use, and so on and so on. So, and then you look at the Caetano case from 2016, where the Supreme Court says that you and I and our listeners have a right to modern firearms. that this argument that we're only entitled to muskets is silly. No, it's like, again, the argument that Supreme Court points out, which we've all pointed out before, it'd be like saying you have a First Amendment right to pamphlets, but not a First Amendment right to use the TV or the telephone or the internet. That's clearly not how the Constitution works. So again, keep in mind that
I think they called it borderline frivolous.
It did, borderline frivolous. So the bottom line is, when you're dealing with a gun ban case or an arm ban case, as long as it's in common use. Now the question is, what does in common use for lawful purposes mean? Well, the best indication is from the Caetano case, which talks about stun guns, which were invented in the 1970s, being in common use. And Justice Alito, in his concurrence, talks about approximately 200,000 stun guns being owned by Americans for lawful purposes. He doesn't discuss about stun guns being used for self-defense or the number of times they're used for self-defense or anything like that. He just points out that possessing stun guns for Americans, 200,000 or more, that's in common use. And I think that's very important to understand, because the Bruen methodology, which is the text first and then history second, has already been done when it comes to these ban cases, like so-called assault weapon ban cases. So it should be very easy for our side to win these cases as they move forward in the system.
Okay, and so we'll go from, because I figured that's where you were going to come down on, and maybe we'll go from easier to harder here.
Sure.
How about the sensitive places laws that you see in New York and New Jersey that they've already been ruled unconstitutional by lower court judges to this point, but do you see any of those restrictions upstanding? For instance, the private property, sort of flipping that consideration on its head. Most states throughout American history have considered it legal to carry on someone's private property unless they post a sign that says you can't. Now these states want to do the opposite of that, where make it illegal to carry on private property unless the owner posts a sign that says you can. Do you see that standing up?
I think almost all the places that the government has defined as sensitive places, which, as you know, is a euphemism for government mandated gun-free zones, are going to fall by the wayside. And let me tell you why.
All of them. Included. What about the ones that the court has?
Almost all of them. Almost all of them. There are, in fact, and the Supreme Court already said this, there are places that can be government mandated gun-free zones if government wants to do that. For example, if you read the Nysurpa versus Heller case, they make 3 examples. They say that a sensitive place can be a polling place, a sensitive place can be a legislative chamber like Congress, and a sensitive place can be a courthouse. Now, if you go back in time and you take a look at this, you'll see that these sensitive places, they all touch on government. They all had, certain aspects of protections and whatnot. They weren't just, stores, taverns. They weren't farmhouses, any of these sorts of things. So let's just take New York. So New York says if a place serves alcohol with a license for alcohol, that's a sensitive place and they can ban guns there. That's clearly not true, because remember, the first thing to understand, Stephen, about the sensitive place analysis is what Bruen's methodology is. So the first thing is, Bruen says you look at the text of the Second Amendment as interpreted by the Supreme Court. And once that text implicates a right to keep and bear arms, then the burden shifts to the government to come forth with historical analogs. So the first question is, when you're dealing with historical analogs, Stephen, is where in time do those historical analogs come from? And the answer is, they come from the 18th century, in the time period of the adoption of the Bill of Rights in 1791, because it's black letter Supreme Court precedential law that says that when you're interpreting the Bill of Rights that was adopted in 1791, you look to the intent and the understanding of the people that adopted it at the time they did it, which is the late 18th century. So you get past 1826, which is the year that Thomas Jefferson and John Adams both passed away on July 4th, 1826, on the 50th anniversary of the signing of the Declaration of Independence. We're certainly indicating there's some divine intervention there, right? You get past that, the founding generation is, by and large, with very few exceptions, has passed away. So anything after that is not going to teach us as lawyers or judges, what does the Second Amendment mean? Because it's too late in time. The founding generation is gone, right? We're dealing with other generations, and their intent doesn't matter so much. So you go back to 1791, Stephen, and you try to figure out what are the sensitive places. And again, you have those 3 examples: polling places, courthouses, and legislative chambers. And beyond that, you really don't have any. We know that you could have alcohol in places. For example, Francis Tavern in New York City, the Patriots met there over beer and they talked and they all had guns. We know, of course, that in Boston, they would meet at Sam Adams' place. And there's countless examples. There's a famous story of Thomas Jefferson leaving his pistols behind in a tavern on his way to Congress, a famous letter that he wrote. So, that's an example. When you go back in time and you look at historical legal analogs of bans of guns in sensitive places, they're very, very few. Now, you do bring up this notion of the default rule. The default rule in American history is you are allowed to bring guns onto private property unless you are stopped. The only kind of, and the best example of that is think about hunting regulations where in America, generally speaking, you're allowed to hunt on other people's lands unless they do a proper posting that says no hunting. Again, right. The presumption is that you're allowed to bring guns onto other people's land unless they tell you not to do so.
Yeah. And so, that does seem like an extremely novel approach that they're taking in New York and New Jersey and probably California here soon. But I think that alone, doesn't that call it into question just because it's never actually been tried anywhere before?
Yes, exactly right. Because the Supreme Court has said that this is what it said in Bruen. If there is a social problem at the time of our founding that the founders looked at, had to consider and deal with, and if they did not deal with it in the form of some form of gun control, that basically tells that the Second Amendment does not permit it. So I'll give you an example. So the anti-gunners in America are trying to say that wherever a lot of people congregate, that is a basis for us to say you can't have guns there. But now let's go back. So let's go back as historians, applying the text first and then historical analog second, which is what Bruen tells us to do. You go back to the founding fathers and you ask yourself at the time of the founding, when people congregated together, did they ban guns if there's a fear for safety? And the answer is absolutely not. They went just the opposite direction. The best example of this is churches, where every Sunday, everyone in the community, including, Indian tribes and criminals and others that might want to do harm to the colonists or the patriots, they would come together at a church on a Sunday morning. Everyone knew this. And what did the founding fathers do when people congregated together? They did not put up no guns allowed, right? No guns allowed here signs. Instead, they encouraged people to bring guns to church. So that's a kind of historical example the Supreme Court said is very telling that when you interpret the Second Amendment in modern America, what did the founders think about it? And when you had people congregating together, the answer was not gun control. It was just the reverse. It was let people bring guns. In fact, actually encourage people to bring guns to defend the community. And that would be an example of talk about, Times Square and all these other things, which of course, putting up a sign that says no guns allowed is absurd. The founding fathers were very familiar with the Italian Enlightenment philosopher Cesare Beccaria, who wrote extensively in a book called On Crimes and Punishment that the founding fathers used extensively to write our Bill of Rights, including the criminal procedures, the Eighth Amendment, cruel and preventions of cruel and unusual punishments. But in that book specifically, he talks about the right to keep and bear arms. And Cesare Beccaria literally writes that any laws that forbid the carrying or use of firearms by private citizens does absolutely nothing except help the criminal and hurt the law-abiding. That is not an NRA slogan, Stephen. That literally comes from the 18th century, Cesare Beccaria, whose book was so influential to the founding fathers that it was basically assigned reading at the Constitutional Convention.
All right. Well, let's get into some more difficult, I think, issues to suss out how the court will react to this or how these will turn out. Let's go back to some of these below felony conviction level gun bans that exist. So you've got, the felony indictment gun ban. It's a little bit odd because you're not barred from owning guns. You're just barred from obtaining them. And then you've got the one that's gotten a lot more attention recently, which was the Fifth Circuit's ruling on domestic violence restraining orders, saying that is not enough to bar someone from owning firearms either. Where do you think that the court is going to come out? Do you think that case is going to make it to the court relatively soon? It's like one of the first circuit court decisions in the post-Bruen era. And it seems like something the government is going to appeal, presumably. Seems like it's set up to be a Supreme Court case, potentially. Do you think it's going to make it there? What do you think is going to happen with that case and similar cases?
Well, things have changed in terms of the dynamic of how cases get to the Supreme Court involving the Second Amendment. Historically, if you look at cases like Heller, you look at cases like McDonald and Bruen, you see these were cases brought by people that wanted to keep and bear arms. They were civil cases challenging going up to the Supreme Court. But because of NYSERPA versus Bruen, you're seeing more and more of the Second Amendment being asserted as a defense in criminal indictment, criminal cases. And of course, historically speaking, in the court systems, because you're dealing with people's liberty interest, meaning we're going to put you in jail, criminal cases often have they take priority in terms of speed because of the nature of the beast. And yes, I think what we're seeing here that's a little bit different is criminal defendants are using the Second Amendment in NYSERPA versus Bruen to assert these various defenses. And we saw that in the Rahimi case where, he said, I was caught, I was allegedly, he had a gun when he was subject to a domestic restraining order. But he said, look, under the Second Amendment, I'm entitled to my fundamental rights until I'm convicted of something, at least. And I haven't been convicted of anything here. And just a restraining order, which is, a lot of these restraining orders could be rubber stamped. I mean, restraining orders just means I'm not allowed to come near somebody. They're anyone who's practiced law in the real world, meaning you're actually dealt with courts, you're actually in there with judges, and you know how the real world works. Sometimes the making of the sausage in the legal system is not that pretty. And whenever there's any kind of suggestion that someone is not going to behave, it's not that hard to get a restraining order because judges are like, hey, I'd rather just give a restraining order because I don't want to appear in the cover of the New York Post as not giving a restraining order, and then someone does something bad and kills an ex-boyfriend or ex-girlfriend or something. So judges have kind of an incentive to, enter restraining orders on, shall we say, not necessarily the strongest evidentiary record. Now, I don't know the specific details.
I will say in this case,
go ahead.
Yeah, in this case, this guy, it's actually kind of a little bit odd because he's almost certainly going to lose his gun rights anyway because he's charged with like 5 other gun crimes beyond possession with the restraining order, including a number of like assaults with firearms. So he's facing a bunch of charges in state court that haven't completed. He hasn't been convicted yet, but yeah, see, he seems like a pretty bad guy. He's accused of being a pretty bad guy at least.
And that's the thing, Steve.
But I'm more interested in
right. Until you're convicted, you're free. And I mean, that's the American system, and that does seem to be a really big, you're a free man and you're innocent.
Yeah, it seems to be a really big part of why the Fifth Circuit, and the same for the felony indictment ruling out of Texas. A lot of the concerns seem to be around the fact that this was not a conviction that we're talking about. These are civil proceedings, and they couldn't find a historical analog. I will say that they came closer in this case, I think, than some of the other ones. Surety laws are, they determined for a number of reasons that they aren't an analog, but they said that they're closer than some of the other defenses that were put up. What I'm interested in is whether you think the Supreme Court is going to take this and what you think they'll do with it.
Well, the reason why I mentioned about the criminal cases is there's a whole host of these 18 USC 922G cases, percolating through the system. That, of course, is the prohibited person aspect of federal law. And there's a whole mess of these coming up under the different provisions. In fact, the Third Circuit Court of Appeals we mentioned earlier in the Range versus Garland case is a prohibited person case. Right. So really, see, what I suspect is going to happen is in the next 6 to 8 months, there's going to be a series of these cases are going to find themselves at the cert petition before the U.S. Supreme Court. And it's not unusual for the court to look at a series of similar cases and try to pick what they consider to be the best vehicle for setting law in America. Because as you know, the United States Supreme Court, as a general matter, is not just about who wins the case. It's also about what precedential value can be set, what teaching value can be set by a particular case and its opinions. And, that is a major factor when the Supreme Court decides whether or not to take a case. So I do think the Rahimi case is important, but it's going to be competing with other cases up there as well.
It's not a lock that they'll take that Fifth Circuit domestic violence case, but do you think they'll probably take some sort of prohibited persons case?
I think in the next 12 to 18 months, they are going to take more than one Second Amendment related case. If you look back in time, Stephen, going back decades, it's not unusual for the United States Supreme Court to take multiple First Amendment cases or multiple Fourth Amendment cases or multiple Fifth Amendment cases in a given term. So here with the Second Amendment, they've been taking Well, you took one case in 2008 with Heller, one case in 2010 with McDonald, one case in 2016 with Caetano, a case in 2022 in Bruen, for example. So you see that spaced out. I think that there's a very good chance over the next, 12 to 24 months, Stephen, we're going to start to see the Supreme Court take multiple Second Amendment cases in a given term to try to flesh out the edge cases, to try to help courts make sure they get it right. Again, it goes back to the Supreme Court is not just about winning and losing. It's also about teaching the lower courts how to follow the law and interpret the Constitution and apply the law going forward all across America. So I think that we're going to start to see multiple Second Amendment cases in a given term in a way we haven't, in the last 50 plus years.
That would make a lot of sense given how much litigation there's been since Bruen came out, and that the government, the federal government is probably going to want the court to take a lot more cases where that hasn't really been the prerogative up to this point. But another question I have on where you think the court is going to go with, especially some of these prohibited person cases. Obviously there's what Bruen says and how the test is meant to be conducted. And then there's also some of the other things that the court has said in dicta, right, in Heller and in Bruen, and in concurrences like the Roberts and Kavanaugh concurrence in Bruen, that lead me to think at least that they may not always strictly follow Bruen, or at least not the way that you or I might expect a case to come out under Bruen. Do you think, how much do other considerations come into play when you're talking about how the court handles these sorts of things? For instance, the domestic violence restraining order prohibition, or let's say the domestic violence misdemeanor conviction prohibition. These are very popular things. People don't like domestic abusers to have guns, right? But at the same time, are there historical analogs to justify these sorts of prohibitions? I think that's less clear. But I wonder what the court would do in this situation, because for instance, the Kavanaugh and Roberts concurrence, they basically say that shall issue gun carry permitting is perfectly fine, but they don't offer any sort of historical analogs for that process. So, what do you think the practical outcome of these cases is going to be?
Well, I think the practical outcome is that the court, as an institution, likes to do things incrementally. And the example I like to give is you think about the gay marriage, again, which is a completely different composition of the Supreme Court, of course. But if you go back to the 1970s, there's an attempt to make gay marriage a fundamental right. And that requires a series of incremental decisions where they start off with, let's make sure we have a right to privacy. Let's make sure there's a right to sodomy in the case called Lawrence. Then let's make sure you can't discriminate under certain laws against, gays and lesbians in the case of Romer out of Colorado. And you see these precedents build up over time, and eventually it gives rise to the Obergefell case that says there's a right to gay marriage in America. Now, I'm not drawing the analogy here to the Second Amendment, which is actually a text-based right. But the truth is the Supreme Court does like to do things incrementally because it's part of our common law system of case builds upon case builds upon case. And I think that if you want to ask me what is the real purpose of the Kavanaugh-Roberts concurrence, I think what they're really kind of signaling to litigants is to say, look, we don't think a facial challenge to shall issue permitting regimes is really where we're interested in going to next, because there's other things that probably need to get cleaned up in the law first before we look at those items. And I think that's a big part of it. The other thing, though, that's very favorable, the Kavanaugh-Roberts concurrence is not anti-gun in any respect. In fact, there's some very powerful language in there that's going to be very favorable to challenges to licensing divisions where these people are going slow or they're harassing law owners and making them, for example, submit references or employer information or, letters from a family member, this kind of stuff. If you look at the concurrence by Roberts and Kavanaugh, they say there's two problems with New York's may issue permitting scheme. One, of course, is it treats it as a privilege, meaning it's the government gets to decide whether or not you get the gun right, the right to carry the gun. That's the first part. But there's a second equally important thing they talk about. They say that the big thing here is it gives discretion to government officials, and that discretion is not permitted. Now, when the government official is trying to look at a letter of reference, they're trying to look at your social media accounts, they're trying to talk about your mental health or physical records, right? What are they doing? They're exercising their discretion to determine whether or not you can exercise your right. So the Kavanaugh-Roberts decision, in addition to the majority decision, is very favorable because they say that any discretion exercised by government agents in terms of determining who gets the right to carry guns is not permitted. And I think that language actually is going to turn out very favorable to the gun rights community going forward over the next couple of years, because it really is going to take away discretion on the part of government officials to deny us the right to keep and bear arms, which is happening in certain places even to this day, so I hear.
Yeah, that's a very fair point. I just also look at how the court has acted since Heller, and I see a court that's, yeah, to your point, moving fairly slowly on some of these things and waiting for, at least up till now, public opinion to lead the way in a lot, maybe not intentionally, but that seems to be how it's come out. Like, Heller says you can't ban handguns. Well, by that point in time, 2008, the idea of a handgun ban was extremely unpopular. It wasn't back in, the 60s and 70s necessarily, but it was by 2008. Same thing for, may issue gun carry, or this idea that you can basically effectively deny people the ability to carry a gun for self-defense, that had been at one point almost completely banned, at least for concealed carry, throughout the whole country. But by last year, no one banned totally concealed carry, and only 8 states had these may issue schemes in place. So, the court isn't necessarily way ahead of public opinion on in those regards to this point. And that's where I wonder, how eager they are to move ahead of it in some of these areas.
I think this court is, if you just step back for a second and look at the composition of the Supreme Court and what they've done since the nomination and confirmation of Justice Amy Coney Barrett. I mean, they've taken on and overturned Roe v. Wade in the Dobbs case. They've taken on affirmative action at the University of North Carolina and Harvard this term. I mean, these are big decisions. They did the NYSERPA versus Bruen case. They have a case called Harper versus Moore, which is a huge case we've talked about on my channel, The Four Boxes Diner, of how important this may be in terms of denying state courts the ability to basically rewrite, legislative maps for federal elections, a very big deal that the progressives in America are very nervous about. So this is a Supreme Court that's willing to follow the law where they think it takes them. And I don't think they're sticking their finger in the wind trying to sense where public sentiment is, because if they were going to do that, they never would have taken like the abortion case, the affirmative action cases, or Bruen or any of these other cases. So I think you're looking at a court that's trying to get it right and bring the Constitution and constitutional rights back to where and restore them to where it never should have left.
Interesting. No, that's a fair point. I think it is legitimate to say that this court is more aggressive in that regard than some of the previous Roberts courts. But let's talk real quick here about that sort of overarching legal strategy that has played out. Something that gun rights advocates are going to come up against, I think, in future cases. And I think that Oregon TRO denial that you mentioned earlier in the show sort of encapsulates what I believe is going to be a common template for upholding modern gun laws by judges who are looking to do that. And so I wanted to just talk a little bit about how that she goes about doing that in that case, and get your thoughts on this strategy and whether you think it's going to be effective or if this is just a one-off. But basically, the argument seems to go, well, there's two, right? The first one, and I imagine you agree with me that this is probably not going to last. The first one is to argue that, high capacity magazines, in this case in Oregon, aren't protected by the Second Amendment because they're not arms, because you don't need a 10-round magazine to operate even a semi-automatic firearm. that approach you've seen a couple of times in different areas for just saying, well, do the first step. This isn't covered by the Second Amendment, even when it seems very questionable to make that assertion. Do you think that is going to continue to be a popular tactic among judges who want to uphold modern laws?
I think it's a popular tactic among the anti-gun lawyers and the government lawyers that are trying to uphold gun control laws. Because again, the way it's supposed to work under NYSERPA versus Bruen is you read the plain text of the Second Amendment as those terms are defined by Supreme Court precedent. So when you look at the right of the people to keep and bear arms, you look at how they define arms, which is all bearable arms. And the reason why the anti-gunners want to fight everything out at the plain text level is because the burden of proof, once the plain text is implicated in a case, the burden of proof shifts to the government to come forth with historical analogs, which is very difficult to do because in 1791, there are relatively few gun control or gun-related laws. So the anti-gun and the government lawyers are really working hard to try to fight it out at the plain text. But the truth is, magazines are arms because you can't operate a semi-automatic modern firearm without magazines, whether it be fixed or detachable. You still need a magazine. And we know that both in Heller and the Caetano case, the Supreme Court says that modern firearms are protected arms. And what is a modern firearms? Well, it's a semi-automatic rifle or semi-automatic handgun. And right. What do you need for a semi-automatic firearm is you need a magazine. And so now you have magazines are arms. And once they're arms, the burden shifts to the government to come forth with a historical analog from 1791 or from that time period to show that, there are firearm capacity limitations in any respect. And those simply do not exist at all. So the government loses. So, yeah, I think that Oregon federal judge is a template, but again, we'll see. I think she may turn it around in the next 6 to 8 months because, as you know, in Oregon, that law has been enjoined by the state courts. So the emergency is no longer in the federal system because it's not in effect. But I think that there's a good chance that federal judge, going down the road is going to get it right because on a TRO, sometimes the judges don't like to, they feel like they're under too much pressure to act quickly and not study the case. But I think when that judge studies the case in Oregon, I think there's a good chance that Judge Gut is going to get it right.
I think that's interesting, but more interesting to me than that first argument, right? So this is what she first says and then just says, I don't need to do the rest of the analysis because this isn't protected by the core of the Second Amendment, sort of a short circuit way out of the doing analysis. But she actually does go on and offer a Bruen analysis as well, which I think is more interesting and likely to be more influential, which is essentially that Bruen allows for the idea that there are modern situations that come up because of modern weaponry that didn't exist at the time of the founding, that the founders didn't have to grapple with, that require modern solutions, right? And in those situations, you can analyze by analogy, right? This is where a lot of the historical analogy stuff comes in. And the judge argued that because mass shootings were not as much of an issue during the founding era, that these are a modern problem, and that in her analysis, she argues that high-capacity magazines that hold more than 10 rounds are sort of a catalyst for mass shootings, that therefore she can analyze by analogy, and she uses an extremely broad view of what is analogous to she sort of, that's where it's, I think, more of a first draft thing. She kind of just throws every gun law that existed during the 18th century at the wall, and even some from the mid 19th century. But to conclude that effectively magazine bans are fine because of this construction under Bruen. What do you think of that approach?
It's clearly wrong, very easy to rebut, and I don't think she will make that mistake a second time because remember, as I mentioned earlier, when you're dealing with a ban on arms, whether those arms are magazines, whether they're bullets, whether they're guns, the Supreme Court has already done the Bruen analysis. The Bruen methodology of text first, history second, was done by the United States Supreme Court in gun ban or arms ban cases in Heller. And all the Second Amendment plaintiff has to show technically speaking, the government has to show it's not true, but set that issue aside. All the Second Amendment plaintiff has to show is that the relevant arm is in common use. And when you're dealing with magazines that hold more than 10 rounds, there's hundreds of millions of these in America. They're ubiquitous. So she applied the wrong standard because she thought she, as a district court judge, which Article 3 of the United States Constitution refers to as inferior courts, meaning they're inferior to the Supreme Court, she applied the wrong legal standard because the standard is the Heller test, which is in common use, which again, if an arm is in common use by Americans for lawful purposes, which semi-automatic rifles are, semi-automatic handguns are, magazines that go in those weapons are, bullets are, because they're needed for guns to function as guns, those are all in common use. They are protected, period, full stop. Now, there are two arguments that you've mentioned that the anti-gunners are trying to develop. They're trying to say first, well, these are technological advances that are brand new, and it's simply not true. And we know that. Don't trust me. Trust what the Supreme Court itself has said. I mean, Heller said that modern handguns, which are semi-automatic handguns, are protected arms under the Second Amendment. Brett Kavanaugh, who's currently a Supreme Court justice, when he was a judge on the D.C. Circuit, on the D.C. Court of Appeals, in a case called Heller 2, wrote a dissent saying that obviously if semi-automatic handguns are protected arms under Heller, then semi-automatic rifles are protected arms, and he said that. And then, of course, in Caetano in 2016, the Supreme Court, with Ruth Bader Ginsburg on the court, said that obviously modern firearms are protected by the Second Amendment because modern technology is protected by the Bill of Rights, just like in the First Amendment and other amendments, right? And specifically, Justice Alito, in his concurrence in Caetano, literally uses the words semi-automatic pistol, as in semi-automatic pistols are protected by the Second Amendment. And again, that means magazines, by definition, are protected. So there's nothing new about this technology. And of course, historically, and I've written about this in my books, the Girandoni air rifle that held between 20 and 24 rounds at the time of the founding was, walked out west by Lewis and Clark. When President Thomas Jefferson sent them out west to explore the Louisiana Purchase territory, which we bought from Napoleon Bonaparte, they brought weapons that held between 20 and 24 rounds. So it's not like the technology was new. And of course, we know in Article 1 of the United States Constitution, one of the Congress's powers is to create a patent and useful arts office to approve and encourage technological advances. So the founders were well aware that technology was going to improve. So the other point, though, Stephen, I'll touch this quickly, that they mention is that there's new phenomena out there. There's a new social problem that the founding fathers were not aware of. And they try to say there's mass shootings, mass killings. But again, anyone that knows any basic American history knows that's not true. Let's just start with the most basic observation. In the year of our Lord, 1770, right at the start of sort of the very beginning of the process that gave rise to the American Revolution, you have something called the Boston Massacre. The Boston Massacre was when British soldiers shot in a mass shooting in downtown Boston 11 Americans, 5 of whom were killed. It is a mass shooting in the year of our Lord 1770, in the middle of our founding generation. That is beyond, of course, all the various, Tory raids and Indian raids that literally killed dozens of people in single incidents, all across the colonies, not to mention the fact that the Gordon riots, which of course took place in London, England at the time, but so they were in a different country, but, Americans considered themselves to be part of the English system. The Gordon riots in a period of 5 days killed 600 plus people. So the founding fathers were well aware of the dangers of mass killings and mass shootings, and it was a social problem they were aware of. And I go back to the church example. When you were worried about a mass killing of congregated Americans, such as they were in the case of churches, what did the founding fathers do? They did not put up no guns allowed signs. They did not ban guns. Instead, they actually encouraged people to bring guns to church. So any suggestion that mass killings or mass shootings is a new social phenomenon is simply historically not true.
Yeah, I mean, I think those are good critiques of this argument. I still think that argument is probably going to be repeated a number of times in federal courts around the country as some lower court judges try to uphold some of these restrictions that exist. But yeah, I think you've laid out a pretty good case as to why this doesn't work. That doesn't necessarily mean it's not going to keep coming up, right? But thank you so much for taking the time to be on with us and to give us this insight and give us an overview of what's going on in the legal landscape, because you are one of the people that I think is more knowledgeable about this than anyone else, honestly. So let people know where they can find more of your analysis if they want to keep up with you.
Sure. Well, I mean, I try to put out a video every day on some of these geeky legal topics at the Four Boxes Diner YouTube channel. I really try to get into the weeds because I think it's very important. I think a lot of, judges and law clerks and lawyers and people, legal intellectuals, scholars, kind of do like to look to see what I say, because I do publish a lot of articles and law review articles, really in the sort of the detailed, the bowels of the legal system, as you will, because, before I became kind of a scholar academic, I was a longtime trial lawyer at major law firms in New York City. So I'm kind of a uniquely situated, Steve, in that I really have seen the realities of the American legal system as a litigator, as a lawyer representing clients all over the country in major matters. But then I also have kind of this, sort of academic bent. So I have a unique perspective on where I think things are going in the courts, because I, sort of done it for clients for many, many years, in addition to the fact of my support of the right to keep and bear arms, which I do think is our most important freedom.
Yeah. And I mean, I think your knowledge really shines through in a lot of your videos, and that's why I enjoy them. You don't rely on clickbait headlines or anything like that. Your content is very much in line with, how you've been on our show today. And it's very detailed and focused on the law. And I think you have great analysis, certainly a really good pro-gun perspective on what's happening in the courts with the Second Amendment. Probably the best I've seen on YouTube, honestly.
Well, thank you. Appreciate that.
And it's popular, which is, almost shocking. You have 100,000 subscribers now. So congratulations on that.
Thank you very much.
And it goes to show that that sort of serious content can be very popular on social media places like YouTube. So I appreciate seeing that as well. So people should head over there and watch some of your videos after they finish this podcast, because it's really valuable stuff. So thanks for coming on.
Thanks, Steve. I just want to add one more thing, though. What is a shame is that the heroic story of America and the role of the firearm in preserving our freedom and creating the greatest country that's ever existed on planet Earth, the heroic story of the gun and patriots and our history seems to be lost on purpose in many parts of this country. So one of the things I try to do on my YouTube channel is I do try to talk about the heroic American, the heroic America. I'm not saying that we're perfect or that anything is perfect. Nothing is perfect involving the human experience, but a lot of good has came out of this country, and I don't intend. I certainly don't want that to get lost, and I hope it doesn't. I hope I can help preserve it.
Absolutely. Well, we will have to have you on again and sometime in the future to get your expertise on topics as they roll out, especially these federal court cases that are coming in a mile a minute. So
great.
Really appreciate you coming on, and we'll see you again soon.
Sounds good. Thanks for having me on, Stephen.
All right, it's time for the weekly news update. I'm contributing writer Jake Fogelman, joined, of course, by Reload founder Steve Gutowski. How you doing this week, Steve?
I'm doing all right. Still recovering from the Super Bowl. That sucked, but I'd be more upset if we hadn't won the Super Bowl a couple of years ago. I think, there's a lot of things. Still pretty annoyed at the NFL with how terrible that field was. The NFL. I mean, the best pass rush in a generation, and they couldn't even do anything because they slipped all over that field. Chiefs played on the same field and all that, but of course the Eagles' whole defense was built around that pass rush. So, and obviously that holding call at the end it really ruined a really strong game. It's not a guarantee that the Eagles would have come back and score, obviously, but took all of the tension out of it, of course, with the ticky-tack call like that. Anyway, maybe the Sixers will get there and lose 2 this year. there's a real chance that they could do that too.
That classic Philly pessimism. I like it.
Yeah, well, it's very much reinforced these days.
Yeah.
Keep getting to these championships and then losing them. It's the third one.
Right. But anyways, on to the gun news of the week. We have a new development out of Florida where Governor DeSantis has now commented publicly on sort of the relationship between the gun industry and the finance industry and the banks. And you have a piece about a statement that he made on what he plans to do. If you want to fill us in on what's going on.
Yeah, so DeSantis had a rally on Tuesday with the leader of this Senate, the Republicans in the Senate in Florida, and the Speaker of the House in Florida, who's also Republican. And they talked about their proposal to enact regulations similar to what Texas has done with banking, which is to target banks that implement a ESG agenda. So basically they incorporate sort of social considerations into their business decisions. And so they don't do business with oil companies or private prisons or especially the firearms industry for our purposes here. But yeah, so he proposed, there's not written legislation yet, but the three of them said on the stage that they're going to effectively bar big banks that have these sort of policies from doing business with the state of Florida, right? So they're using Florida's municipal funds to combat this, what they call a woke agenda, right? From these large financial institutions. And so that means, we won't give them government contracts from the state of Florida. They won't keep the state of Florida's money in their bank accounts at these banks and stuff like that. So it's a fairly significant thing, mainly because of the size of Florida, right? Texas did this. And, those two states alone have quite a lot of economic power behind them. So, it's a pretty big cudgel, I guess you could say. And they're going to use it in this case to try and prevent banks from dropping gun businesses.
Yeah, no, I think it's definitely a big deal because obviously Florida is at this point a deep red state. I think after November, they now have a supermajority in the legislature. So obviously whenever a formal bill does get introduced, there's a good shot that it passes. And Florida, as you said, joins Texas as these two big red states with massive market potential that can kind of flex their muscles a little bit in the finance industry. And I think politically, this does a lot for DeSantis, who has made some positive comments around guns and being pro-gun generally, but doesn't really have a long track record to show for. And obviously, I think everyone knows he has higher political aspirations. So I don't know what you think about that, how that helps his odds maybe down in a crowded primary field down the line.
Yeah, certainly. I think that this is part of his strategy on guns going into the Republican primary. But yeah, he is sort of shoring up his right on the issue of guns. They've also proposed constitutional carry, permitless carry in Florida as well, which he's supported in the past, but hasn't really made a push for in the same way that, Kemp did in Georgia. And Florida is one of the only triple red states that doesn't have permitless carry at this point. So he's kind of behind the curve on this issue. And now it seems like they're going to pass that bill, and he's incorporating the gun issue into his sort of anti-big bank agenda now as well. And I think that's all on purpose. It's fairly smart politics with the bank stuff, because he was already, likely to make these kind of moves over, other aspects of what the banks are doing. He accuses them of using a social credit system that disfavors, right-leaning businesses or individuals. And so they had a specific example during this event where Brandon Wexler, who owns Wex Gun Works, which is a story that we reported on, he was dropped by Wells Fargo Wells Fargo had sent him letters that said he was a risk and that it was because of the industry that he worked in, which is, dealing firearms, but didn't give any further details as to what the risk was. And then later claimed that it doesn't have anything to do with the fact that he's a gun dealer and that they're committed to staying in business with gun companies. But obviously this created a lot of news and controversy. And so Wexler was actually there at this event speaking with the governor. And so he took this story, he took this, what happened with Wells Fargo, and is incorporating that into what he was already doing, which was using, sort of state government power to push back against corporations, large corporations that he thinks are woke or are, pursuing a social agenda that he doesn't like. Obviously he had the fight with Disney, and now he's doing a similar playbook with big financial institutions like Citibank or Bank of America and Wells Fargo. So it's fairly smart politics, I think, to do that, because Florida has a really good reputation for being pro-gun, but in recent years has really fallen behind the rest of, red America, at least when it comes to actual policy.
Yeah, I agree that it's very politically savvy. Regardless of the merits of the policy, it definitely plays well to the sort of brand he's been building. Kind of, as you pointed out, he sort of staked his reputation on the guy that's willing to fight against these, woke corporations or whatever, and to rope firearms in there, which is obviously going to be a big primary issue, at least on the Republican side. That's pretty much all upside, I think, for him for a potential presidential candidacy, trying to fend off other rivals. Like you pointed out, Kemp and Abbott, we don't know if they're going to run, but they're, at least potential contenders. And he's no longer vulnerable on those issues if he can, raise his profile doing things just like this.
Yeah, I mean, it's something that might turn off, your more libertarian leaning conservatives. Right. But I think over the last 4 or 5 years, you start to wonder how many of those actually exist, even if you are one. Right. And so for Republican primary voters, they definitely seem to want this sort of government action against the companies or groups that they perceive to be, their enemies or the people who are against them. Right. And so, this kind of combines that's been his real marquee thing as governor. And so this is a way to incorporate a new issue into that political strategy. And it probably is a pretty smart move in that regard for the people he's trying to appeal to. And, certainly it'll be interesting to see, like he's vulnerable on this issue to people like Kemp or Abbott in Texas who were ahead of him. But are they even going to run? Is this going to be more than a 3 or 4 person race by the end of things? How many other people are actually, further to the right on guns than he is? Because Trump has a fairly mixed record himself. Certainly, he instituted the bump stock ban unilaterally, which just got struck down as unconstitutional in the Fifth Circuit. He made a lot of comments after Parkland about taking people's guns and then having due process later. There was a lot of public comments. Obviously, at the same time, he's gone to every NRA convention. The NRA is kind of, in his pocket in terms of they're extremely tied to Trump at this point. And they're still, as we've talked about before, the largest group despite all their struggles. And then, of course, he has the sort of Trump card, I guess, to say, of appointing 2 Supreme Court justices who have been, on the pro-gun side in this major landmark ruling we've covered extensively, in Bruen. So, certainly shoring up his position on guns with some actual accomplishments while he's, before this primary really kicks off would be smart politics.
Yeah, I think one thing that'll be interesting to watch is just how these banks react. Obviously, Texas passed this policy, and you saw like Citigroup, for example. I think that was like the big sparring partner with the Attorney General Ken Paxton over there, where he was going to review all the contracts with the state of Texas and review Citi's policies to see if they're in line.
And he said they aren't. He certified that they're not.
decertified them from doing
even
business
though
with the state of
Citibank
Texas.
claimed that they were, sort of paradoxically, because Citibank hadn't changed their. So
Right,
you know,
they
the core of this
previously
issue
made it.
is like Citibank and Bank of America, for instance, had actual policies that they put out that they said they wouldn't work with companies that make AR-15s or sell them, or same thing for magazines that are high capacity, although they don't define what that means. And it means different, just like assault weapon. It means different things depending on what state you're in or how people are defining it. These are nebulous terms, but so they've sort of wanted to use their bank's influence to try and force gun companies into, you know, not making these legal products. And that's what a lot of people have gotten upset about over the years. Right. And so that's where this all stems from. But Texas, the Attorney General there, as you mentioned, decertified them, or, said that they weren't in compliance with this law. And so that, it has repercussions on both ends, because Citibank can't do business in the largest state in the, one of the largest, it's the second largest, right? In the country. And then, so I think California's still bigger.
They still,
if I remember correctly. But, they can't do business there with the state government. At least they can still, operate in Texas. They just don't get state contracts. But at the same time, it makes doing state business more expensive, because they have to go out and find other banks. And so they generally get charged more money. But, I think a lot of people who support these sort of policies see this as, an intractable battle. Like if the financial industry shuts out the gun industry, how can you do business at all? And
right.
that's where I think the support for this comes from.
Yeah, especially when the big ubiquitous players like your Wells Fargo's, your Bank of America's, the ones that are in every state and usually have one of the largest market shares, shut you out. I certainly, see the appeal. I just wonder if we'll see more, like, for example, in the story that you wrote, Wells Fargo put out, I think it was from the last letter they sent to Brandon Wexler, where they said, "Oh, don't worry, we intend to continue doing business with the firearms industry." So we don't know if they're going to continue to put out symbolic statements like that, or maybe symbolic statements, or if they'll actually see a change in their lending practices and their banking practices.
Right. I mean, that's the thing about Wells Fargo, is that they never made one of these statements that they wouldn't do business with certain kinds of gun companies. They just have been accused, at least by, the National Shooting Sports Foundation, for instance, of sort of backdooring a policy like that, where they do what they did to Wexler, which is like they cut ties, but they don't explicitly say that it was because, you're selling certain kinds of guns they don't like. And so that's much harder to prove, obviously, especially if Wells Fargo comes out and says that's not what's going on. And so a law like this might be harder to use against a bank like Wells Fargo. And they're probably doing that in. It was interesting to see Citibank try to get certified in Texas anyway, they never came out and said they were changing this policy, but, they tried to say that they were in compliance with what the, technical rule in Texas is. The Attorney General, of course, rejected that. And that's probably what it'll come down to, is like, what is the Attorney General in these states? What do they decide about what constitutes complying with this sort of mandate? And again, this is about, it's sort of they're not trying to ban Wells Fargo or Citibank or any of these other large companies from doing business in the state. They're using government resources to, to say that we're not going to have our accounts with you. So it's probably safer in terms of, judicial review in that sense. The state can choose who it wants to bank with, but, they'd have a lot more trouble if they tried to, shut down Citibank in all of Texas or all of Florida. So it's a little more savvy than something like that, but it will be interesting to see how this plays out and what kind of effect it has. Because, like I said, it's doing damage to both ends, where, Citibank and Bank of America and Wells Fargo are going to have trouble getting these large state contracts. And then at the same time, those states are going to have trouble getting the best rates when they go to finance debt or what have you. And so it'll be interesting to see how that plays out, whether one side blinks perhaps or what happens. But certainly we will be following it. And it'll also be interesting to see how this strategy plays out in the Republican primary, right, which is right now looking like it's going to be pretty competitive between DeSantis and Trump. Of course, it's very early, and how things look very early in a primary tend not to be how things turn out by the end of one. So we will have to see how all of that plays out, and we will be following it here at The Reload. So make sure you stay tuned, subscribe to this channel on YouTube, follow us on your favorite podcasting app, share this content if you want to help us reach more people with what we're doing. And, of course, head over to thereload.com and check out our membership options today if you want to support our work. That is how we fund our reporting. This is the only way. It's member funded. We are a small company that is not owned by any giant corporation or some shady investors or whatever. Our members are the people who fund our reporting. And so if you want to be part of that, you can head over and join today. You'll also get, of course, exclusive access to hundreds of pieces of member-only content, a lot of analysis pieces. I'll have a piece on this DeSantis situation this weekend in the members-only Sunday newsletter as well. And you'll get access to this podcast a day early, too. And the opportunity to appear on the show, which we'd love to have another member segment. It's one of my favorite segments that we do. So please reach out. Just reply to your Sunday newsletter if you are already a member and want to be on the show. We would love to have you. And until next week, we will see you guys.